Welcome back to Law and Crime. I'm Carissa Kranz, and you were just listening to testimony from the defendant himself. He took the stand in his own defense. And while we're listening to the testimony so far, he's doing a good job. I actually think it did help him in his case to take the defense. However, Aaron, it's so great to have you on set with me and not hosting a show and across from me. And you know, it's
usually we're switching very quickly.
Right, right. On that 56-second mark, we have to switch and mic up real fast. Okay, so we also don't have a whole lot of time before the next break. I'm so excited about this chat room, and one of the people in the chat room, Smiley Nee, asks a question. So I'm going to ask that question, and you got tipped off because you already read it, didn't you?
No, I didn't.
Oh, you okay? Great. So then you're on the hot pot. Ready? What are Aaron's thoughts on the defense bringing up the prior road rage incident after the judge had already ruled it out?
You know,
that's a great question.
I was trying to figure this out the other day too, because look, to really understand it, I'd have to get into the nature of the evidence ruling, and I was wondering if it had something to do with impeachment rules, because in some states you can impeach a witness that you call, and in other states you can't. And I was wondering if it had to do with that. I was also wondering if it had to do with the fact that the defendant himself chose to take the stand, and maybe the judge's ruling, which said that it can't come in, was predicated on a presumption that the defendant wouldn't take the stand.
So are you saying because the defendant took the stand, he sort of opened the door?
Yeah, I mean, maybe it came in as impeachment, but not for the truth of the matter, and that might have influenced it as well.
So if the judge ruled it out and then it came in anyway, kind of as bombshell testimony, could that be grounds for a mistrial?
I'm sure that there probably was some kind of a motion for one. I didn't see the exact moment the other day, but look, I mean, different states have different ways to deal with evidence issues like this. Oftentimes when defendants take the stand, evidence can come in under impeachment, but not necessarily as evidence that's entered for the truth of the matter. It's just, you know, it just opens a different door up here, and I'm wondering if that's what happened.
So he opened the door. If we look at the chat, everyone should go to the chat, lawandcrime.com. Go to the chat room. You can take part in this with us. It's really fun. Kathy says that once the defendant takes the stand, the prosecution could bring it up, and that's her understanding. And for those of you who know Law and Crime and have been with us, Kathy is the person we go to for all of our fact checking, and she really knows what's up. So I would guess, Aaron, that to answer Smiley's comment, that you're right. He opened the door by taking the stand.
That's my guess. I mean, and I'm trying to loop myself back through all of the different character evidence rules as well, because sometimes if the defendant gets on the stand and says something that opens the door up just a smidge for some character evidence, sometimes they can bring even more of it in, and maybe that's how it came in as well.
Okay, and then another question that I see here from Tig Penn. Does Aaron think that the jury is looking at a lesser verdict since they asked about the tortoise? The tortoise. Sorry,
I didn't catch that part of it. I mean, again, I wasn't here for some of this because of the Huber's case and whatnot. I mean, it's always possible. We never know quite what the jury's thinking.
Okay, we're going to go back to testimony in the courtroom from the defendant, Oliver himself, and then we'll be back here for some more fun in-studio analysis. Welcome back. I'm Carissa Kranz. That is the defendant, Roy Oliver, taking the trial in his own defense. He is standing trial right now. He was taking stand in his own defense. He's on trial for murder. He's a former officer. He killed a 15-year-old black kid. What happened is he responded to the scene of a party. There were shots fired across the street, unrelated gang shots. There were about 150, 200 kids in this house party. It was late at night. There were 2 officers responding on scene. And the question is was it reasonable or not for this officer to shoot into the car full of teenagers under the circumstances? And would an officer with his level of education and experience under those circumstances react the same way? That is the question. With me, Aaron Keller. Let's discuss. What do you think?
Okay, so I think that the jurors should hopefully be zeroing in on the video, because that's what tells the story that really can't be twisted too much by either the state or by the officer. After they start with the video, they got to back it out and say, okay, what's the law say about what can be done by the officer in a situation like that? And look, it seems to me that this is unreasonable. That's just my take on it. I'm
right,
wondering if they're actually...
So that's your verdict, guilty then. You're saying unreasonable. We're in verdict
that would be
watch.
mine.
We're in verdict watch.
That would be mine. And of course, you know, you hate to say that because you hate to see someone who takes an oath and then puts himself in difficult situations wind up coming out on the other end of the law. But I don't see any sense that anyone was really in harm's way based on that footage. That's just me. And I wonder, you know, is the jury back there looking at that footage, or are they more worried about definitions?
Well, right, and that's a key point. So the footage, for those of you who may have missed a piece of this, the body cam footage shows different facts in the officer's narrative of what really happened. The officer says he shot at the car because the car was going towards his colleague, and then really what happened with the body cam is the car was actually pointed away. So we're in verdict watch. Who knows how the jury is dissecting all this? I would love to be a fly on the wall in that deliberation room. We're going to continue to monitor this. We have to take a quick break. Stick with us. We'll be right back. Welcome back. I'm Carissa Kranz. That is the defendant on cross-examination, taking the stand in his own defense. With me, Aaron Keller. We do not see defendants take the stand very often in trials because it subjects them to cross-examination, which is what we're listening to right now. And what you said was key when we were listening to this testimony, that we need to talk about not just the technicality and the law, but the facts surrounding all this and whether or not it was reasonable. So why don't you comment on that?
Okay, so what strikes me when I hear this testimony, and every time we hear it in almost every self-defense case, we have a pretty wide chasm, I believe, between what the training that these people say that they have tells them to do, what the training dictates over here, and then what the law actually says or how the law characterizes these situations over here. And he keeps parroting back his training. I have to stop the threat. I have to stop the threat. I have to stop the threat. Well, where is the analysis of whether the threat is reasonable? Because that's what the law dictates. And we don't hear that. We just hear him saying, well, my mind perceived a threat and therefore I had to eliminate it. Where is the testimony about the analysis of the severity of the threat? That's what I want to hear. And it makes me wonder whether or not their training actually matches what the law says.
So, and the other question is he trained right now to take the stand and argue that it was reasonable? Is he trained right now and rehearsed right now to come up with his circumstances around these circumstances, which could lend validity to his case that it was reasonable under the circumstances? Because remember, we heard from the other officer who responded on scene, and we heard his testimony, and he said he did not feel an imminent threat. He did not feel the need to shoot. He did not feel in fear of his life, and the car was not going towards him. It was going away. We have to take a quick break. Stick with us. We'll be back in just a few minutes. First, let's take a look at the top crime stories trending around the country.
Here are today's top crime stories trending on Law&Crime.com and across the country. A couple arrested in a New Mexico Muslim compound for allegedly training children to conduct armed terrorist attacks reportedly picked a hospital in Atlanta, Georgia as a target. The couple, Jani Levele and Siraj Ibn Wahaj, were arrested after authorities raided their compound. 11 children were taken into custody, and the body of a boy was found 3 days later. Authorities claim one of the children, said Levele, mentioned Grady Hospital in Atlanta as a target for attack. The couple remains in custody at a federal holding facility in Texas. A former video game tournament champion turned gunman opened fire at a live stream tournament in Florida, killing 2 people before turning the gun on himself. 24-year-old David Katz of Baltimore reportedly opened fire at the Madden NFL 19 online tournament at a mall in Jacksonville before killing himself. EA Sports, the maker of the Madden video game franchise, lists David Katz as the 2017 championship winner. Authorities are now using online videos that captured the scene before the shooting for clues. 9 other people were injured in the shooting, but are expected to survive. The family of late rock icon Prince filed a lawsuit in Hennepin County District Court against the doctor who they say overprescribed pain pills to the musician. The lawsuit alleges Dr. Michael Schellenberg failed to diagnose and treat the Little Red Corvette singer's opiate addiction prior to his death. Prince Rogers Nelson died of an accidental overdose of the powerful opiate fentanyl on April 15, 2016. His family is seeking unspecified damages in excess of $50,000. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thank you, Anthony. And let's just talk for a minute about that last story where Prince's family is bringing suit, a civil lawsuit, against the doctor for negligence, for not acting according to industry standards or reasonably under the circumstances by not treating his addiction to opiates and therefore overprescribing, costing him his life. Aaron, I'm a civil attorney here. I do injury law. What do you make of this case? You think it's a case?
Well, look, I mean, you've got to. What are they trying to say? Are they trying to say negligence here?
Yes,
okay,
negligence.
So negligence. So there's got to be a duty breach. There's got to be causation.
Right.
There's got to be harm.
That's what's being alleged.
Okay, so it's like the duty to prescribe. I mean, how are they going to get to that?
Well, we already know that that this doctor prescribed, not even to him directly, they prescribed to someone else to try to protect his identity. So,
which is certainly bizarre, but was it based on not even looking at the patient, Prince himself, or was this just some like privacy go around? And does that directly lead to liability?
And that's something that they're going to have to look into.
See, there's been fines assessed
Right.
against this guy separate from this case.
Right.
But I'm trying to figure out,
for prescribing
okay,
to the wrong person.
You know, how often did he treat Prince? Did he know his complete medical history? Did Prince go to him and say, I have this issue, where the doctor should have looked at that and said, I know what that is? Or did he just say, I'm having trouble with X, Y, and Z, and then the doctor says, oh, there's a pill for that, and I prescribe it? I mean, how much information was traded back and forth between the patient and the doctor? How long of the relationship did the patient and the doctor have? I'm just wondering, you know, how was he supposed to prescribe this, or how was he rather supposed to diagnose it?
Well, he probably was aware of the problem, and that's why it was prescribing to someone else in order
probably.
to... Well, right. But so this is a civil lawsuit. We don't have to have beyond any and all reasonable doubt. We just have to have more likely than not. Is it reasonable to believe? Is it probable? That's what it is. Is it probable? Is it probable?
I mean, I think we need more facts about what went on in the treatment room between these two in order to really assess this fully.
And what I can tell you
right
as an injury lawyer, this case is going to settle for money. It's not going to get thrown
I mean,
out.
I think that there's a strong chance of that. The
that's
question is
why-
how much money.
And that's where the argument's going to lie, how much money. But the family is bringing a lawsuit because the family knows that there's negligence. The family knows that there's been wrongdoing, and they're going to bring a lawsuit. They brought the lawsuit because they know they can collect, because the doctor already has a shady record, which is why he was already assessed $30,000 in fines. Switching gears, Shayna Hubers, the trial that we have been watching closely here on Law and Crime, garnering much media attention, been on 48 Hours the first time around. She is on retrial after already being sentenced and convicted for 40 years for killing her boyfriend. She claims it was self-defense. Prosecution says nope, it's because she wouldn't allow him to break up with her. We have a 911 call. Let's go to that call when she calls 911 after she kills and pulls that trigger. Welcome back. I'm Carissa Kranz. That is the interview in the interrogation room of Shayna Hubers. And there you hear her. She already invoked her right to counsel, but then she sits there and she continues to babble for hours and hours, and investigators have to cycle through and circle through the room because she's talking without them asking questions. She's giving up information. And as Lobby said, but Lobby just said goodnight on the chat, Lobby said she's certifiable. But then we have Aaron here speaking to her mental defects, saying maybe it's no excuse, but he's actually sort of defending her. And then Lobby says, what happened to Aaron? Did Aaron fall in love last week with Shayna? Aaron says no, said he did not fall in love with her, but he can speak to no.
I don't know where some of this stuff is coming from.
The law chat.
Well, yeah, but I mean, look, I was sitting there in court. You pick up on all this body language when you're there.
We got to take a quick break. Stick with us. We'll continue to dissect this and have fun in the newsroom. Well, there you have it. That is bombshell testimony from Shayna Hubers herself, taking the trial and taking the stand in her own defense. Interesting testimony, things coming out that would not have come out in the first trial because the only way to bring it out is through her own testimony. The question is are the jurors going to believe what she's saying? Is she rehearsed? Has she prepared for this? How is she going to do on cross-examination? And basically, is this believable? Aaron, I know that you were there. You had the opportunity to assess her in person, and that's always more valuable than through a live feed and a video. You actually get to pick up on whether someone's actually getting it or not.
I mean, it seemed to me from the body language that you know, I believe that there's some mental health diagnosis there that's real based on the body language. Now, the question is that an excuse for the crime charged? You know, I was on the fence in the beginning of the case, but I'm hedging that I don't think it is now because I've listened to more of the evidence. One thing that becomes a little bit unbelievable in the testimony is all of this evidence which suddenly now comes out 6 years after the original crime that she had suffered all of this sexual abuse here, there, time and time again. This is all new. Exactly. Why haven't we heard it before?
Exactly. Is that true? Is this rehearsed? Has the defense really prepped their client to put on the best case possible to try and get a different verdict? We have to take a quick break. We'll be right back. Stick with us in just a few minutes. Welcome back to Law and Crime. I'm Carissa Kranz. We are watching the Shayna Hubers retrial right now. That's what we're following here. This is the case where Shayna Hubers is standing trial for murder of her boyfriend, often coined the nose job killer. She already stood trial about 6 years ago, was sentenced to 40 years in prison, found guilty. But because a juror was a convicted felon and that was not disclosed, she now has a retrial. In the first trial, she did not take the stand in her own defense. This time, she is taking the stand. We have her testimony. She is on the stand, and it is creating quite a debate. Some people think she's redeeming herself. I still think she is so guilty. But we have some in-studio analysis that we're going to come back to with Aaron Keller here. And he is commenting on her redeeming qualities, and him and I are not in agreement. But hey, that's why there's two sides to the story.
I didn't say that there were redeeming qualities. I think that this relationship was very, very troubled. I mean, you know, he would so-called break up with her and then allow her to come back into his life. And all the breakups were over text. And if you really deconstruct what his family and friends were testifying to, and again, I was there for this. We can only feed back a certain number of minutes of clips. But if you listen to the whole testimony, his friends kept telling him, his family kept telling him, look, Ryan, you need to be a man, break up with her face to face, do it cleanly and do it finally. Okay. You can't keep allowing her to kind of come back because it's confusing her.
Or there's another comment that I could say to that. There's a flip side. He didn't want to break up with her to her face because he feared for his life and he feared what she was capable of.
Okay, so he's an attorney. He could have found a way to deal with that if that was indeed a problem that he was contemplating.
But clearly she took matters into her own hands. Look what she did. I don't know. I don't think we're going to agree.
Then why? Okay, so if he really feared her, why is he bringing her to the gun range? Right before this happened.
He tried multiple times to break up with her. She wouldn't allow him to break up with her. And you know, sometimes people get mean in order to force someone to leave. It didn't work out well for him. He ended up dead. And who knows if things were different, if it would have turned out differently. Nonetheless, we have more testimony from Shayna Hubers on the stand. So let's take a look at what she has to say. Welcome back. I'm Carissa Kranz. What you heard on the stand right there is testimony from Doris West. She is a neighbor of the boyfriend, the victim, Mr. Poston, who died at the hands of Shayna Hubers. Her testimony is important because she can speak to what happened right before and right after she heard the shots fired. What's also interesting to point out is that is a video testimony that you're watching on the live feed. And that is video of her testifying in the first trial, because now 6 years have passed and they said she is not of right mind, she's too old, she's too frail, she's not well enough to testify again in this trial. So the jurors have to rely on the testimony, the direct and the cross, whatever came into evidence in the first trial for this trial. Aaron Keller, I want to give you the opportunity to comment on her testimony, its significance. What do you feel is coming out of that testimony that's important for the prosecution's case?
Well, look, I mean, I think that it's concerning that she claims that she suffered the volume and the type of abuse that she claims to have suffered, and this is the first time we're hearing of it. Because to me, the rest of her statements can be colored with that. Hey, wait a minute, if you suffered sexual abuse from this person, that person, and the other person, why are we hearing about it for the first time 6 years after this crime? Why didn't we hear about it back in high school when you claimed that one of the acts happened? And everything she says can be colored with her own, unwillingness to sort of like tell the whole truth when she had the chance before. And I think it colors a lot of the rest of her discussions and her statements over the years.
So are you saying that, because we just heard from the defendant, that she's believable now or not?
I'm sitting here trying to figure it out, and I don't have to make the ultimate decision.
That's true. The jurors get to make the ultimate decision. It is a different panel of jurors this time around. They get to decide whether or not she'll be found guilty again or not. Stick with us. We'll be right back after just a few moments and this quick break. Welcome back. I'm Carissa Kranz. That is testimony from Holly Nivens. She is a witness for the prosecution. She's also a former cellmate of the defendant, Shayna Hubers herself, and she is giving incriminating testimony as if the defendant herself made admissions once behind bars after the first conviction, which is pretty damning to her case, if you are to believe the former cellmate. With me, Aaron Keller on set. Want to talk about this. What do you make of this cellmate's testimony? Believable or not? Okay,
so if the jurors give credit to that cellmate, this is guilty. Okay, right. Shayna Hubers has been twisting the marionette lines from behind the scenes for years. She had the thing all planned out. She knew how she was going to play her cards before she even pulled the trigger. If the jurors credit that cellmate, it's going to be
right,
guilty.
Because that cellmate's giving testimony explaining how she rolled up her sleeves and she has self-inflicted bruises, and how she basically rehearsed the entire thing with her mom on how she was going to...
And knew what excuse she was going to give after the fact.
Which, let's talk about that for a second. Could the mom be charged with anything as an accomplice?
I'm not seeing enough evidence for that, but again, I'm getting this part of this in bits and pieces as well.
Okay, we're going to go back to more testimony from this witness on the stand, because this is really critical testimony. And as Aaron said, if the jurors believe this, it is a guilty. Let's take a look.